Section 504, Meeting the Needs of Students with Disabilities. Section 504 coordinators are required to attend annual training on the procedures associated with Section 504 of the Rehabilitation Act of 1973. Learning objectives. The participants will be able to identify students that may be protected under Section 504. Describe the rights and protections of students with disabilities under Section 504. Become familiar with addressing the needs of students that are medically homebound. Develop an awareness of local processes and procedures regarding students with disabilities that require a 504 accommodations plan. Now we will review the laws protecting students with disabilities. There are many areas of overlap between Section 504 and the Americans with Disabilities Act, which are civil rights laws. Both are designed to protect against discrimination, and both use the same definition of eligibility. Section 504, however, only applies to recipients of federal financial assistance, while the Americans with Disabilities Act, or ADA, and the Americans with Disabilities Act Amendments Act of 2008, or ADAAA, also apply to organizations that do not receive assistance. As you can see from the illustration, the ADA and ADAAA are all-encompassing. Students that have 504 accommodations plans or IEPs are protected by Section 504, the ADA, and the ADAAA. Additionally, students with IEPs are also protected by IDEA, which is an Education Act. We will now discuss the definition of disability and the identification of students with disabilities. Who are these students? A person is protected under Section 504 if he or she has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. A team should consider all medical documentation but cannot unreasonably delay a meeting because a parent is unable to provide medical documentation. Section 504 regulations apply to students in preschool, elementary, secondary, and adult education. The eligibility team, including the 504 coordinator, a minimum of one general education teacher, and the parent determine if a student has a physical or mental impairment which substantially limits one or more major activities when the condition is in its active state. Please note that a team should consider all medical documentation. What does physical or mental impairment mean? Any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, including sense organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin, and endocrine. Any mental or psychological disorder, such as cognitive impairment, organic brain syndrome, emotional or mental illness, and specific learning disabilities. When determining initial eligibility, the 504 team specifically lists the mental, physical, or emotional impairment. The team may or may not have received medical or psychological information and cannot require that information in order to move forward with the eligibility determination. The evidence of an impairment should be reviewed, and the team needs to determine if the evidence supports the determination. If there is documented evidence, the 504 coordinator is required to describe in detail what that evidence is, and who the evaluator or physician was on the eligibility worksheet. The Office of Civil Rights recently provided specific guidance regarding the diagnosis of ADHD. In OCR's guidance, they state, every type of ADHD affects the functioning of the parts of the brain related to thinking, concentrating, and planning. A determination that a student has any type of ADHD, therefore, is a determination that a student has an impairment for purposes of meeting one of the prongs of Section 504's definition of disability. Further, a diagnosis of ADHD is evidence that a student may have a disability. OCR will presume, unless there is evidence to the contrary, that a student with a diagnosis of ADHD is substantially limited in one or more major life activities. Major life activities include certain acts a person does, such as hearing, speaking, lifting, and a person's bodily functions, such as lung disease that affects a person's respiratory system, or a traumatic brain injury that affects the function of the brain. The type of major life activity that is affected is recorded on the 504 eligibility determination document. The team should discuss and identify the major life activity or activities that are affected by the mental, physical, or emotional impairment. School staff should note in particular that a student may have a disability and be eligible for Section 504 services even if his or her disability does not limit the major life activity of learning. Therefore, rather than considering only how an impairment affects a student's ability to learn, school staff must also consider how the impairment affects any major life activity of the student and, if necessary, assess what is needed to ensure that students have an equal opportunity to participate in the school's programs. Some examples of a major life activity that could be substantially limited by ADHD include concentrating, reading, thinking, and functions of the brain. Major bodily functions may include functions of the immune system, normal cell growth, digestive, bowel, bladder, respiratory, circulatory, endocrine, reproductive, brain, and neurological function. What does substantially limits mean? Significantly restricted as to the condition, manner, or duration under which an individual can perform a particular major life activity as compared to the condition, manner, or duration under which the average person in the general population can perform the same major life activity. The determination of substantial limitation must be made on a case-by-case basis with respect to each individual student. The team may wish to replace the word significantly with to a large extent, considerably, greatly, or noticeably in order to more clearly understand a student's substantial limitation. Section 504 requires that, for elementary and secondary school students, a group of knowledgeable persons draw upon information from a variety of sources in making this determination. It is expected that a school 504 coordinator, parent, and a minimum of one general education teacher will attend a 504 team meeting to discuss the individualized needs of the student. All of the student's teachers should contribute meaningful information prior to or during the team meeting. A student may have a disability and be eligible for Section 504 services even if the student earns good grades. The student's impairment may substantially limit a major life activity regardless of whether the student performs well academically, and may need Section 504 protections or accommodations because of this disability. For example, a student who has dyslexia and is substantially limited in reading finds it challenging to read the required class material in a timely manner. Alternatively, a student who has been diagnosed with depression may be substantially limited in her ability to concentrate while completing school assignments. For a student that has been diagnosed with ADHD, staff should ask how difficult it is or how much time it takes for a student with ADHD in comparison to a student without ADHD to plan, begin, complete, and turn in an essay, term paper, homework assignment, or exam. In all of these cases, the student spends far more time preparing for class than other students. The student would still be substantially limited in a major life activity despite earning good grades and may require a multi-sensory approach to learning and additional time to complete assignments, projects, homework, quizzes, or tests, even if that student earns mostly A's. Here are some examples of students substantially impacted. A student with a visual impairment who cannot read regular print with glasses is substantially limited in the major life activity of seeing. A student with an orthopedic impairment who cannot walk is substantially limited in the major life activity of walking. A student with diabetes who requires insulin injections is substantially limited in the operation of a major bodily function, the endocrine system. School staff should note in particular that a student may have a disability and be eligible for Section 504 services even if his or her disability does not limit the major life activity of learning. Therefore, rather than considering only how an impairment affects a student's ability to learn, school staff must also consider how the impairment affects any major life activity of the student and, if necessary, assess what is needed to ensure that students have an equal opportunity to participate in the school's programs. These examples also illustrate the importance of having the right people at the table. For a student with a vision impairment, it may be more important to have a teacher of the visually impaired at the meeting than a school psychologist. A student with an orthopedic impairment would benefit from the expertise of a physical therapist. Collaboration with a school nurse would be a priority for students with diabetes or other health conditions. Record of a disability. To be considered an individual that is protected under Section 504, a student could have a record of a disability. Having a record of a disability means that a person either has a history of a disability or has been misclassified as having a mental or physical impairment that substantially limits one or more major life activities. For example, a person who had heart disease, cancer, or a mental illness may have a record of a disability but no longer have the impairment. An example of a misclassification would be a school district that incorrectly identified a student as having a learning disability when further testing revealed the student's issues were caused by the need for ordinary eyeglasses and the student does not have a learning disability. A student who has a record of a disability may or may not need special education or related aids and services. Section 504 does not obligate a school district to provide aids or services that a student does not need. But even if a student with a disability does not need services, the student is protected from disability-based discrimination under Section 504's general non-discrimination requirements, regarded as having a disability. A student could also meet the definition of an individual with a disability by being regarded as a person with a disability. This could mean, for example, that the student does not have any impairment, but is treated by others as having a disability. For example, a person who does not have a physical or mental impairment that substantially limits a major life activity, but who is not allowed on the soccer team because of the false belief that the student has HIV, would be regarded as having a disability. Note, as stated previously, although the student regarded as having HIV in this instance is not entitled to receive aids and services, the student is nevertheless protected from disability-based discrimination under Section 504's General Non-Discrimination Requirements. School districts must conduct an evaluation in a timely manner of any student who needs or is believed to need special education or related services because of a disability. When a school team is aware of a student's disability or has reason to suspect a student has a disability, and the student needs or is believed to need special education or related services, it would be a violation of Section 504 if the school delays or denies the evaluation. In some circumstances, the IDEA evaluation process may provide the school district with the necessary information required by Section 504 to determine whether a student has a disability and whether that student needs related aids and services or supplementary aids and services in the regular education environment because of that disability. A school district must evaluate a student if it has reason to believe the student has a disability and the student needs special education or related services as a result of that disability, even if the student only exhibits behavioral and not academic challenges. For example, those students who have a high number of disciplinary referrals for inappropriate verbal outbursts in class as compared to their peers could be students with disabilities in need of services. Some students, due to an unaddressed disability, may engage in behaviors that do not conform to school codes of conduct because the students are not receiving needed special education or related aids and services, including needed services to address behavior. These and other indications that a student's behavior is out of the expected range of behaviors for students of similar age may trigger a school district's obligation to evaluate under Section 504 to determine whether the student has a disability and needs special education or related services as a result of a disability. A school district must, at no cost to parents, evaluate students who are suspected of having a disability or more than one disability in all related or all specific areas of educational need. For example, a student who is easily distracted and unfocused may be manifesting attention deficit hyperactivity disorder or ADHD, depression, or a specific learning disability. There is a range of physical or mental impairments that could cause a student to have a disability under Section 504 or to need special education or related services because of that disability. But this determination cannot be made without first evaluating the student. If a student has a suspected impairment that may require specially designed instruction or additional information to determine eligibility, such as ADHD, vision impairment, hearing impairment, dyslexia, autism, or an emotional disability, we would be required to refer the student to an evaluation planning team meeting in a timely manner to consider an evaluation. Be aware of some referral red flags, such as lacking valid documentation of impairment, not passing academic subjects, not meeting expectations in recent district or state tests, pattern of disciplinary referrals or significant behavioral disruption, or difficulty accessing the general education environment without the need for specialized instruction. Staff or parents may request consideration of Section 504 if a student has an acute health, safety, or transportation need that requires immediate attention. This can be addressed through initial eligibility or temporary eligibility if the team lacks sufficient information to rule out IDEA. Staff or parents may also request consideration of Section 504 for less acute impairments that may or may not require specially designed instruction or additional information. Expedited temporary eligibility may be an option for students that we do not know well. As an example, a kindergartner who is referred for Section 504 consideration right before enrollment that has a serious health condition. Temporary eligibility may also be appropriate for a student who has a new diagnosis and the team is aware of additional academic concerns. The student may be referred to the evaluation planning team if appropriate. If the student is made eligible under IDEA, a Section 504 discontinuation document will be generated by the School 504 coordinator. If the student is not eligible under IDEA, the team will reconvene within 45 school days and the information gathered will be considered through a 504 reevaluation review when addressing the student's eligibility and accommodations. If the team agrees that IDEA has been ruled out, an expedited initial eligibility should be completed. If a student has a suspected impairment that may not require specially designed instruction or additional information to determine eligibility, in other words, there's no reason to believe the student has a disability requiring special education or related services as a result of disability, the team can go forward with initial eligibility. The School 504 coordinator should refer to the Section 504 eligibility team to consider eligibility. Recent screening should be referenced or acquired. The school psychologist is not required at the Section 504 eligibility meeting but may attend. If the student has a suspected impairment that may require specially designed instruction or additional information to determine eligibility, in other words, there may be reason to believe the student has a disability, then the team needs to refer the student to the evaluation planning team. To identify next steps, the team completes screenings if recent screenings are not available, social developmental history, and observations. The team completes evaluation planning paperwork in Enrich. If evaluation is determined to be needed, all special education evaluation procedures are followed. If evaluation is not needed, a 504 eligibility meeting may be convened immediately following conclusion of the evaluation planning discussion. Please note that psychologists are not required to attend 504 initial eligibility meetings, but can be helpful in some circumstances. School 504 coordinators should refer to the initial referral flowchart to ensure that the school team is moving in the right direction. First, determine if the student's impairment involves an acute health, safety, or transportation need, or if the impairment may or may not require specially designed instruction or additional information. Next, determine if the student will be referred to a 504 eligibility meeting or an evaluation planning team meeting. Be certain that the right people are involved at each step. There are additional considerations when identifying students. Students who have conditions that may be episodic or in remission may qualify for Section 504 eligibility. Examples of impairments that may be episodic or in remission might include cancer or severe seasonal allergies. The 504 team would consider the substantial impact when the impairment is in its active state. Some students with impairments that are episodic or in remission may be eligible but not currently need a 504 accommodations plan. These students' needs are reviewed annually after eligibility is determined. The positive effects of mitigating measures cannot be considered when making the disability determination. If a student is regularly receiving a therapy, a 504 team may determine eligibility based upon consideration of substantial impact if the student were not receiving this mitigating measure. Determining eligibility for Section 504 protections and the need for an accommodation plan are two separate decisions. Some students may be eligible but not currently need a 504 accommodations plan. Some examples of mitigating measures might be psychotherapy or physical therapy, equipment or appliances, low vision devices, prosthetics, hearing aids, use of assistive technology, reasonable accommodations, learned behavioral or adaptive modifications, or medication and medical supplies. This list is not exhaustive. A 504 team may determine that a student qualifies for Section 504 protections and does or does not currently need an accommodations plan. All eligible students have the same rights. A team is required to meet yearly to review the student's performance and determine if an accommodation plan is needed. The detailed description of the data reviewed will be documented on a 504 meeting summary, and accommodation determination will need to be completed. A team will also need to meet every 3 years for the student's periodic reevaluation review. These students should be documented as eligible for Section 504 protections in PowerSchool. Documenting this information will ensure that their right to a manifestation meeting is provided if necessary. Students with transitory impairments may require a 504 accommodations plan, but are not required to be referred to the evaluation planning team prior to determining 504 eligibility. These are just a few examples of transitory impairments. When determining eligibility, the 504 coordinator would document that the impairment is transitory or temporary and may conduct the meeting via tele or video conference with the student's guardian or the adult student. A transitory impairment accommodation plan may need to be developed before a student re-enters school to assure that necessary accommodations are in place for the student immediately. Isn't a health plan enough to accommodate a student's needs? The answer is, it depends. Our school district has a responsibility to address this question on an individual basis. An individual health plan cannot serve as a substitute for a 504 accommodations plan. Conversely, we cannot assume that a child with a health plan requires a 504 plan automatically. We cannot bypass 504's processes that serve to protect the rights of children with disabilities. For example, in Tyler, Texas Independent School District 111, a Texas district's practice of providing individual health plans to students with diabetes instead of determining their need for a Section 504 plan prompted OCR's concern. In this case, the parent expressed concern that her child with diabetes was missing instruction when he was pulled for insulin shots and the school district delayed evaluating the child. OCR concluded that it appears that students with medical conditions that may qualify for services pursuant to Section 504 are not in fact being referred for evaluations when the school learns of the medical condition, but instead are being provided services through an individualized health care plan. This was an example of the district circumventing 504 procedural safeguards. For many students, a 504 plan that incorporates an individual health plan may be appropriate. Collaborate regularly with your school nurse to identify any students that should be considered for Section 504 eligibility. These are some examples of challenges that students may experience that are specifically not considered to be a disability. While these challenges may not be considered a disability, schools still need to prevent and appropriately respond to all forms of harassment, discrimination, and bullying. Some of these students may also have coexisting disorders, such as an anxiety disorder, that should be considered. Students who are not doing well solely because of environmental, cultural, or economic disadvantage may not be disabled. Additionally, students who are experiencing challenges solely because of their first language would also not be considered disabled. It is the team's responsibility to rule out these factors using multiple sources of information. School 504 coordinators should give accommodations and modifications the substitute teacher test. A substitute teacher should be able to look at a student's accommodations and easily understand what they mean. In a recent guidance document distributed by the Office for Civil Rights, the document stated that many of the complaints filed with OCR alleging discrimination on the basis of disability involve allegations that school district personnel failed to implement a plan. OCR has found that complaints of this type are often the result of either the student or teachers and other staff being unaware that a plan exists, or the plan being so vaguely worded that the parties are unclear or disagree about what the plan requires. Many of the complaints filed with OCR alleging discrimination on the basis of disability involve allegations that school district personnel failed to implement a Section 504 plan. OCR has emphasized the importance of making sure that staff understand their obligations to implement appropriate plans for students with disabilities once the plans have been developed. OCR has found that complaints of this type, again, are often the result of either the student or teachers and other staff being unaware that a plan exists, or the plan being so vaguely worded that the parties are unclear or disagree about what the plan requires. Accommodations must be clearly described in a 504 accommodations plan, and the school 504 coordinator must ensure that evidence is available that all pertinent staff members have received the student-specific accommodations. School 504 coordinators are required to email the plan to all appropriate staff, meet with staff to explain or answer any questions, and have all applicable staff sign a district form. The signed form is then uploaded into the 504 software system and shared with the school administrator. It is the responsibility of the 504 coordinator to ensure that the student's 504 protections are also documented in PowerSchool on the South Carolina Student Information Screen. These are some examples of accommodations that may be necessary for a student to access their education. Teams must consider least restrictive environment, and accommodations should be clearly defined. Extra time should be clearly described and bound. Will the student receive 2 extra days for homework? Time and a half for tests? Will the time frame not exceed a grading period? Any district or state testing accommodations should be those typically used to access the general curriculum during routine instruction. Updated state assessment accommodations resources are available on the District Accountability page and the Special Education Department Accommodations and Modifications webpage. A few references that should be readily available to teams when making accommodations decisions are the South Carolina Accessibility Support Document, the Test Administration Manuals, and the Greenville County Schools MAP Testing Program Guidance for Testing Students with Disabilities. What are modifications? Modifications are requiring a student to learn less material, completing an alternate assignment that is more easily achievable than the standard assignment, completing work on part of a standard, using an accommodation that invalidates a particular construct, giving a student hints or clues to correct responses on quizzes or tests, providing non-standard accommodations or modifications to students during classroom instruction and/or classroom assessments may have the unintended consequence of reducing their opportunity to learn critical content. If students have not had access to critical assessed content, they may be at risk for not meeting graduation requirements. If modifications are being discussed at a 504 meeting, staff have the obligation to make parents aware of this risk. At the same time, if this is an accommodation that the student requires, the team should document the accommodation and consider a referral to an evaluation planning team. Provision of a non-standard testing accommodation on state testing could result in a testing violation. Please note the difference between accommodations and modifications. Accommodations change the how, not the what. Accommodations provide equal access to instruction and assessment. Modifications change what a student is taught or expected to learn. Modifications may reduce the standards and are more likely to be provided to students that require specially designed instruction through an IEP. As a reminder, the Greenville County Accommodations and Modifications website should be bookmarked. It contains authoritative sources of information and resources that will assist School 504 coordinators in meeting the needs of students with disabilities. School 504 coordinators must read the applicable Appendix C of the State Testing Manual for understanding prior to developing accommodations plans. When documenting accommodations, 504 teams should keep the following in mind. Teams should identify student strengths and needs before discussing accommodations. Teams should consider access without accommodations, also known as least restrictive environment. Accommodations should be clearly described, objective, and in some instances bound. Subjective language like as needed or when the student's grades are poor should not be included in 504 accommodations plans. This can lead to implementation errors. In addition to standard accommodations, universal supports that are described in the classroom instruction and assessment section of the 504 accommodations plan must be shared with school test coordinators. Accommodations are what the school system or staff will provide, not what the student or parent will do. This information can be referenced in the 504 meeting summary. It should be clearly documented whether an accommodation is necessary for face-to-face and/or virtual instruction. At the middle and high school level, transition age pupils should be consulted, and it is best practice for them to participate in their meeting. Parent permission is required for students that are ages 13 through 17. Now we're going to talk about homebound policies and procedures. How do we determine homebound needs for students with disabilities? Decisions regarding homebound services and accommodations must be made based on an individualized assessment of the student's needs through a process that aligns with the procedural requirements of Section 504. The 504 team or IEP team when appropriate, must meet to determine if homebound is appropriate, the services needed for that student during homebound instruction, and any transition services necessary for that student to return to the school setting. The amount of homebound services considered is never limited by a predetermined number of hours. If a student is being considered for homebound instruction and they are a child with a disability, a 504 meeting must be convened. A full continuum of options should be discussed with the family. I need to make you aware of the Greenville County Homebound Rule IDDC. Additionally, if the student is on homebound for an extended amount of time, it may be necessary to consider if the current 504 plan can meet the student's needs or if the student should be evaluated to determine possible IDEA eligibility. Any medical documentation should always be accepted from the parent and considered. All students should be served in the least restrictive environment. A continuum of options should be discussed and the rationale for medical homebound should be documented. Accommodations should be discussed on an individual basis to meet the student's needs in the home environment. The amount and type of services to be provided should be discussed and should meet the individual needs of the student. The rationale for this amount of time should be discussed in the 504 meeting summary. If the student has behavioral emotional needs, the team should consider what previous strategies and interventions were utilized to address the behaviors. If a physician refers a student for medical homebound due to behavioral or emotional concerns, the 504 team should convene to consider what measures should be taken to address the concern. If the student has behavioral or emotional needs, the team may need to consider accommodations or strategies appropriate for the student to continue to access the curriculum. Homebound is considered a very restrictive environment, and efforts should be made to transition students back to the school setting. When the student is returning to school, it may be recommended, again, to reconvene the team to develop a transition plan for return to school if necessary. Now we're going to talk about Section 504 protections. What does Section 504 say about protecting our students? No otherwise qualified individual with a disability shall, solely by reason of his or her disability, be excluded from participation in, denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance. This includes school-sponsored sports, programs, and online courses. To ensure that students receive their protections, it is very important that they are identified as protected under Section 504 in PowerSchool. This information is entered in the instructional screen. FAPE includes evaluation and placement procedures that guard against misclassification or inappropriate placement of students. Periodic reevaluation of students who have been identified and prior to a significant change in placement. Provision of regular or special education and related aids and services that are designed so that the individual educational needs of students with disabilities are met as adequately as the needs of non-disabled students are met. Education of students with disabilities with non-disabled students, to the maximum extent that this arrangement is appropriate for the needs of students with disabilities. A system of procedural safeguards that is designed to inform parents of a school district's actions or decisions and to provide parents with a process for challenging those actions or decisions. That includes notice, an opportunity for parents to review their child's records, an impartial due process hearing, with an opportunity for participation by the student's parents or guardians and representation by counsel, and a review of procedure. When addressing sports and a student's individual needs, if an accommodation is reasonable, necessary for the disabled student, and would not fundamentally alter the nature of the competition, it is our obligation to provide that accommodation. A modification might constitute a fundamental alteration if it alters such an essential aspect of the activity or game that it would be unacceptable even if it affected all competitors equally. For example, removing a base from a baseball diamond. However, a change that has only a peripheral impact on the activity or game itself might nevertheless give a particular player with a disability an unfair advantage over others, and for that reason, fundamentally alter the character of the competition. For example, allowing a student with a disability to start a race a few seconds before his non-disabled peers. Such changes would not be required under Section 504. Schools also cannot deny equal access to field trips. If a student were denied access to a particular field trip, the burden would be upon the district to prove that the student should not participate. For example, the student participating in the activity would pose a danger to themselves or others. The standards for access to online courses should be consistent for students with or without disabilities. If there is a prerequisite requirement for access to a particular course, the requirement must be applied consistently. An example might be a requirement that a student complete Course 1 before enrolling in Course 2. A student's team should discuss any accommodations that may be necessary in order for the student to have access to the course. The 504 team should be specific as to accommodations that are appropriate in the standard versus the virtual school setting. Once the accommodations are clearly described, it is the responsibility of the school's 504 coordinator to share the information with virtual school staff. Section 504 requires that a student with a disability be educated with students without disabilities to the maximum extent appropriate to the needs of the student with the disability, and that a student with a disability be educated in the regular education setting unless the district can demonstrate that the education of that student in the regular educational environment with the use of supplementary aids and services cannot be achieved satisfactorily. Accommodations should be documented that are necessary based on data that supports the need. According to a 2000 Dear Colleague letter from OCR, states and school districts also have a responsibility under Section 504 to ensure that a free, appropriate public education is made available to eligible students with disabilities. Disability harassment may result in a denial of FAPE under these statutes. Parents have legal rights when their student with a disability is the target of bullying or harassment. Be aware of some harassing behaviors: verbal abuse, name-calling, slurs, graphic or written statements, threats, physical assault, conduct that may be physically threatening, harmful, or humiliating. Greenville County Schools has a bullying training video on the district website that sheds more light on this pressing topic. What if a guardian of a student with a disability believes they have experienced discrimination or harassment related to a disability? The student or parent may submit a written complaint to the school's principal that briefly describes the concern and identifies the offender or offenders. The principal investigates the complaint. Within 10 working days after the complaint, the school principal has a meeting with the complainant to discuss and resolve the concern. If the parent or student is dissatisfied with the decision made by the principal, then a written appeal should be submitted to the District 504 coordinator within 10 working days of the decision given by the principal. At this juncture, another copy of the procedural safeguards should be provided. All 504 coordinators should be familiar with Board Policy and Rule JCDAG. School 504 coordinators and staff have varied responsibilities. As 504 coordinators, these are your responsibilities. Provide school personnel an overview of Section 504 and submit evidence of the presentation to the District 504 coordinator. Provide copies of 504 accommodations plans to any pertinent staff members and document evidence that accommodations have been provided. Serve as an initial point of contact for transfers, inquiries, and referrals, providing parents with information about evaluation, eligibility, and rights. Ensure appropriate information is available for meetings. Convene team when needed in person or via tele or video conference. Teams are required to meet annually but may meet more often. Teams meet every 3 years for a periodic reevaluation review. When organizing a meeting, be certain to invite required participants. For an initial eligibility or an annual review, the participants should include the parent, 504 coordinator, and a general education teacher or teachers. When planning any meeting, you should consider the student's disability area prior to inviting participants. Depending upon the student's challenges, other participants that may be necessary to determine eligibility or accommodations may include a nurse when discussing a health plan, an administrator, or a teacher of the visually impaired, a teacher of the hearing impaired, a physical, occupational, or speech therapist. Also, don't forget the student. There is little specific guidance given regarding required student participation, but the student certainly has a unique perspective on their specific disability and what they may need. Talk to the parent about their expectations for student participation and the benefits of student participation prior to the meeting. Document the parent's wishes regarding student participation in the contact log, the invitation, and the 504 meeting summary. Work with an administrator to ensure 504 accommodations are implemented. Notify the administration and District 504 coordinator of unresolved parental concerns. 504 team responsibilities. The 504 team refers students suspected of having a disability to the evaluation planning team, provides data and observation information to the team for consideration, determines 504 eligibility and conducts periodic reevaluations, develops 504 accommodations plans if appropriate, implements the 504 accommodations plan and documents implementation, reconvenes at least once annually to review and revise plans as appropriate, conducts manifestation determinations when necessary. Processes and procedures through forms. The forms listed are procedural requirements. An invitation is always required and should be provided to the parent or adult student with the parent-student rights with adequate notice. Call the parent to schedule a time to meet before sending the invitation home. Document all contacts with the parent, including how and when the invitation went home, in the contacts log. For an annual or a periodic reevaluation review, if you have provided the parent with 2 notices with adequate notice and the guardian does not appear, go forward with the meeting. Eligibility determination should be completed in detail at initial placement and periodic reevaluation review meetings. Students that transfer into our district should have a periodic reevaluation review or initial eligibility completed within 45 school days. See the transfer instructions in the Section 504 Staff Handbook. The comprehensive review of relevant information should include parent input, objective teacher classroom observations, most recent district or state testing, grades, and any other relevant information. A documentation of diagnosis is not required but is helpful and should always be accepted and considered. The accommodations plan needs to be filled out annually. Failing to meet annually is a violation of federal regulations. Continued need for a plan is revisited annually using the accommodation determination worksheet. Document eligibility in PowerSchool in the instructional settings field. This field will need to be updated this school year if you or your PowerSchool clerk has not already done this. The 504 meeting summary is an additional means of notifying parents of what decisions were made and why they were made. It is required at all meetings. What about those extra forms? The transportation form, if needed, should be filled out at the 504 meeting, reviewed at the end of the year, and resubmitted if necessary. A textbook form will rarely be needed, but if it is, it should be completed at the 504 meeting, reviewed at the end of the year, and resubmitted. If required, the manifestation determination form will be completed through a team process and documentation maintained. When there is a possibility that a student may need special transportation, please consult with the Transportation Department prior to scheduling the 504 meeting to address the student's transportation needs. A representative from the Transportation Department may or may not be needed at the team meeting to plan for the individual needs of the student. Once the need for transportation has been documented in the 504 accommodations plan, complete all sections of the transportation form identifying the decisions made by the 504 team. The form is located on the Documents page of the 504 software system. Once the form is completed, signed by the parent, and uploaded into EdPlan 504, you will need to email the Special Education Department's lead data entry clerk regarding the need for transportation. Delays can occur when all sections of the form are not completed accurately. Additional textbooks are not often needed due to digital text availability. The 504 accommodations plan, though, if an extra text is needed, must document the accommodation of an additional textbook and must be specific regarding each class that would require this accommodation. Some subjects no longer have hard copies of textbooks available. There must be evidence to support the need for extra textbooks, and the 504 meeting summary must document why the team determined that an additional textbook or textbooks was necessary. The textbook form must be submitted to the Special Education Department Curriculum and Staff Development Administrative Assistant via email. Failure to complete the form accurately and in a timely manner may result in federal violations if the team has determined that extra textbooks are necessary for a student to access their education. The manifestation review is a necessary process that needs to be completed through a meeting after a student has been suspended for more than 10 school days in a row, or the student has been subjected to a series of removals for more than 10 school days that constitute a pattern. Students that have been determined to have a disability under Section 504 have similar disciplinary protections as a student that has an IEP unless the violation involves drug or alcohol use. Students that have been disciplined for drug or alcohol use lose their right to a manifestation determination under Section 504. It is imperative that 504 eligibility be accurate in PowerSchool to ensure that students with disabilities are afforded their rights. Regarding expulsion, because an expulsion, along with a long-term suspension, is considered a significant change in placement, a district may not expel a student with a 504 accommodations plan without first conducting a manifestation determination review and finding that the misconduct was not related to the student's disability, unless the student was using drugs or alcohol. If the manifestation determination review team determines that the behavior is a manifestation of the student's disability, then it may not expel the student or take other disciplinary action that constitutes a change in placement, unless the student has engaged in a behavior that is a special circumstance. Under Section 504, if a student's code of conduct violation involves the use of drugs or alcohol, an MDR is not required. Section 504 allows schools to take disciplinary action against students with disabilities using drugs or alcohol to the same extent as students without disabilities. If the student has engaged in any of the listed violations, they may be removed for up to 45 days to an alternate setting as determined by the 504 team, whether the behavior is or is not a manifestation of their disability. Be certain that you have an effective system in place at your school to identify students with disabilities that transfer to your school. Establish who will review the student records received and explain to that individual the importance of identifying students with disabilities, whether those students have 504 plans or IEPs. Once your school receives information from the parent or records from the prior school setting, the school is responsible for implementing the student's 504 accommodations plan and for following local transfer procedures. Your first priority is to share the transfer accommodation plan with all appropriate staff members immediately. Once you have uploaded the 504 transfer paperwork into the 504 software system, you will complete a support request asking that the student's last eligibility date be entered into the software system. Some out-of-state students are required to be referred to the evaluation planning team before holding a 504 reevaluation or initial eligibility meeting. A reevaluation or evaluation planning meeting would need to occur within 45 school days of enrollment. Send an invitation home with a documentation of diagnosis form, but do not delay a meeting if the parent does not turn the form back in. You may also consider having the parent complete a release of information so that you can assist in the process of acquiring medical documentation. For most students, the purpose of the meeting will be a reevaluation review meeting. Only students without initial eligibility paperwork require a 504 initial eligibility meeting. All other students' needs will be addressed through the 504 reevaluation review process. Develop a new plan if the team determines that the student is eligible for Section 504 protections and needs an accommodation plan within 45 school days. This should be completed again within 45 school days from active enrollment or first day of attendance, or the knowledge of disability after attendance. School 504 coordinators can contact the District 504 coordinator via email or phone with any questions. Have a great school year.